doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper, and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses, excluding victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
they also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this, other than maybe we should take it up as we progress through the case, but
Your Honor,
some of these people may or may not be even served.
Yeah, my concern is, obviously, I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point. Then the state can try to, at that point, preclude them. When the state talks about a trial by ambush, it is, in fact, that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit, just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information, because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony is relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're going to have to take up maybe on a piecemeal basis, but I don't want it. It's not going to be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that, and I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them. But I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So We
Well-
are doing the best that we can.
Okay. All right. We next have defendant's motion to dismiss for violation of confidential communication and the Sixth Amendment dated March 18 of 2025 and the state's response. Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really, that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential. And you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not confidential?
Well, the
Who's
jail.
telling me that they're not confidential?
Your own attorney, it looks like. Here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for privileged, confidential, client privilege communications. So
Phone calls.
no, it says this phone number is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential.
Okay.
Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January?
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not.
Strong arguments being made. She's impressive, and I think she's got a point. Once they were informed that that number was part of a confidential line, anything, texts, calls, I think should be confidential.
Because she had an expectation of privacy and that
yes.
being confidential. I don't disagree with you. The other thing the judge pointing out, everything underlying is relevancy. What's relevant and not is a decision for him. Thanks to Philip Dubé for joining us tonight.
Stick around, folks. Coming up in our next hour, we're going to continue to bring you more from the motions hearing in the cult bomb conspiracy trial of Lori Daybell. So keep it here on Court TV, your front row seat to justice.
First order.
Welcome back to Court TV Live. I'm Michael Ayala in Massachusetts. Our coverage of the trial for Ingolf Harry Turk continues today. He's a surgeon accused of strangling his wife to death in 2020. A neighbor returns to the stand to face cross and gets grilled about sexting the victim, Kathleen McLean. And in Michigan, testimony resumes tomorrow in the battered and burned murder trial for Linda Sturmer. And in Massachusetts, the Karen Reed murder retrial gets underway tomorrow as well. Prosecutors say she killed her boyfriend, John O'Keefe, after hitting him with her SUV. The defense says someone else is responsible, and the police are trying to cover it up. Joining me now in studio with all the latest is Court TV crime and justice correspondent Matt Johnson. And Matt, we hear the judge has officially ruled on that third-party defense. Big stuff there. What can you tell us?
Michael, nice to see you. This was a major ruling earlier today. The defense can use third-party defense with Brian Albert and Brian Higgins, but not Colin Albert. Judge Beverly Cannoni denying third-party defense for Colin Albert because the defense failed to show any evidence that Colin had a motive, intent, and opportunity to kill Officer John O'Keefe. And there was no evidence to ever show that he was at 34 Fairview at the same time that O'Keefe was at the home. But the defense can raise third party with Brian Albert and Brian Higgins after these arguments earlier this month.
The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had.
There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. There is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision.
Now, while the defense can raise third party during the trial, Alan Jackson, who's delivering opening statements for the defense this time around, it was David Yannetti last year, cannot mention it during his opening statement, Michael.
Yeah, they were under the same restrictions the first time around, Matt. There was also an emergency motion filed today by Reed's defense concerning jury selection. Tell us about that.
This was a big win for the defense, actually. The judge granting a defense access to the clerk's list of juror names, potential jurors, after Judge Beverly Cannoni ruled that the names were impounded during impanelment and during the length of the trial, citing juror safety. Quote this in her document that she filed: "This case has garnered significant and divisive attention, and at least one deliberating juror from the first trial submitted an affidavit to the court detailing reasonable fear for their safety and for their family should the list of jurors be made available to the public. Only the defendant, Karen Reed, and the defense attorneys have access to the names as they're going through this process. Jury selection, as you know, begins tomorrow morning, Michael, and this could take several weeks this time around."
All right, we'll be watching very closely. Thank you so much, Matt, for that update. I want to turn back now to Arizona for that motions hearing with Lori Vallow Daybell. Jury selection is underway inside the courthouse in Maricopa County, Arizona. It's expected to take several days before a jury is seated, and Daybell is, of course, representing herself as a pro se defendant. Daybell is charged in connection with the shooting death of her fourth husband, Charles Vallow. Vallow was shot and killed by Lori's brother, Alex Cox, in July of 2019. Now, Cox told police that Vallow became violent. Now, that shooting was ruled self-defense, and Cox was actually never charged. Well, now only Lori faces charges in Charles's death. Daybell is already serving life without parole after being convicted in May of 2023 for killing her children, 6-year-old J.J. Vallow and 16-year-old Tylee Ryan. She was also convicted of conspiracy in the death of her current husband's first-time wife, Tammy Daybell. Well, their murders happened just months after Charles Vallow was killed. I want to get you back inside that hearing now. Right now, they are arguing a motion to strike East Idaho news reporter Nate Eaton from the witness list. Eaton has been covering Daybell's cases from the very beginning.
To obtain these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review if she's subjecting herself to client privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney. I have no other way to communicate with him when I'm in this incarcerated situation, because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client-attorney privilege.
Well, not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number, or I call that phone number.
Correct.
So,
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
but I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was just getting them on his same phone that we were having client attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything that warrants them getting them from MCSO in the first place.
All right, let me hear from the state.
Your Honor, I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information. Whether or not she understood it or not, her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privilege information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because of the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this
before.
is not confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is he using it incorrectly?
I just told you. He's not messaging through the phone number. He's using different IP
How
addresses.
can you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? They're given to you by the state?
They're right there listed on the messages.
I'm just saying, where are they obtaining those from?
From your attorney's messages to you?
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from different IP addresses.
Okay, can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
I don't know.
It's not been sent to anyone other than the defendant, Your Honor.
All right. So there was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't purposely sought out by the state. And that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's ordered denying the motion to dismiss for violation of confidential communication. All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 21st. Let me get that. And the state's response. The motion to dismiss for prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have the response. Did you get that response?
Have it up.
Ms. Daybell, did you get that response?
I did, Your Honor.
All right. So your prior attorneys had, actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler Police Departments. I denied the state's request, saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your complaint, that they didn't provide those public documents to the defense. That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that
I'd like to take each allegation and deal with them one at a time.
I understand that. My
allegation.
complaint is the interference by the state, Ms. K in particular.
All right, so beginning to see some of the issues with the pro se defendant. She's sort of in and around these issues, but it seems like she's not really zeroing in on them to the point where the court can understand. Court's trying to explain things to her. She doesn't quite understand. I wonder if this will play out like this throughout the trial. All right, we're going to pause it right here and continue with this motions hearing in Arizona for the Coke Mom conspiracy trial of Lori Daybell. We're going to hear more of the rest of the defense's witness list, so keep it here on Court TV, your fellow seat to justice.
Tonight on Closing Arguments, Karen Reed and the Doomsday Cult Killer. Two big murder trials, and the world is watching. We're bringing you the very latest as both get underway.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
It's a whodunit Hollywood story.
Monica Cimentelli is accused of plotting to kill her husband.
Celebrity hairstylist Fabio Cimentelli.
The celebrity stylist murder trial continues Tuesday on Court TV.
Welcome back to Court TV Live. I'm Michael Ayala. Let's get back inside that Arizona courtroom for the Lori Daybell motions hearing. We're listening to the judge address the rest of the defense's witness list.
Saying they had an issue with this.
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises to prosecutorial misconduct.
It is.
Right. This is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through regarding that.
Which is what?
I'm not going to give you legal advice. All right. Your second allegation, the prosecutorial misconduct, we've already kind of dealt with, that she distributed the state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to the defense witness, Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
It's taking her word for that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there, and we don't know who's saying it, and you're just taking her word for it like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom? I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said, you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can interview him. You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
Not a witness anymore because you just precluded him.
All right. You can interview him. You can have your investigator interview him.
So even though he's not a noticed witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to...
All right, let's bring in our guest for this hour. Joining us to discuss, former prosecutor and criminal and civil defense attorney Randolph Rice. Randolph, great to see you as always. Thank you so much for joining me tonight on the program. And as far as I'm concerned, Lori's, she's doing her thing. But most of what we're seeing here, I think, can be filed under one heading, and that is dealing with a pro se defendant.
Yeah, I mean, this is a dumpster fire on the back of a train wreck, literally. I mean, this is why you have a lawyer representing you, because lawyers know the rules of evidence. They know when and when not to file motions to dismiss. And Ms. Daybell apparently thinks that any type of alleged or perceived slight against her is an automatic motion to dismiss, which is just not the case. It sounds like her and her attorney are not following the rules of the jail, and that she somehow wants the case dismissed because the prosecutor just happened to get them and send them to her. So she really needs to have an attorney there advising her.
Yeah, and so apparently there is one, but maybe she's just doing things her own way. But I got to say this, I really appreciate the judge in this case. He seems to have the perfect demeanor to deal with a pro se defendant. I love the way he's handling it. He's doing his best to explain things to her. I got to question her tone at times, but he's not making a big deal of it. He may have to at some point, but I really appreciate the judge's demeanor. Yourself?
Yeah, I mean, the patience of Job is what you would describe with this judge, and he's trying not to give her legal advice. While he is certainly in the last clip there, he was advising her, look, if you have questions about what was said, what was discussed, you have an investigator. Go use the investigator. So he's dancing around, not giving legal advice. He's certainly not going to direct her exactly what to do and how to do it. But I certainly think he's also trying to protect this case for the potential appeal down the road.
Yeah, no question about it. All right, Randolph, stand by. We're going to take a break right now. When we come back, we're going to get you back inside that hearing for a number of other issues being addressed by this court. So keep it here on Court TV, your front row seat to justice.
Pocket.
Welcome back to Court TV Live. I'm Michael Ayala. We're bringing you that motions hearing in the cult mom conspiracy trial of Lori Daybell. Now, jury selection's also underway. That trial should get started in the next week or two. Daybell is accused of conspiring to kill her fourth husband, Charles Vallow, back in July of 2019. Her brother, Alex Cox, ended up shooting and killing Vallow after he said Vallow became violent towards him and hit him with a bat. The police ruled the case was self-defense and Cox was never charged. Daybell is representing herself at trial. A motions hearing is happening now where they are discussing a defense motion to disclose evidence. Let's get back inside that courtroom.
This time I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Of course.
All right, 609 motion. The state's alleged a total of 7 felony convictions in the state of Idaho. Under Rule 609, the court finds that limiting the number of convictions and the nature of the convictions to be appropriate as to not be overly prejudicial. There is an interest in allowing a jury to know that the defendant's been convicted of at least one felony. But let me hear, I'm inclined to probably limit it to 2 felonies in order that they be sanitized. Does the state want to be heard on that?
Your Honor, I do believe that the court should allow for at least 3. There are multiple dates and multiple victims in those and multiple different distinct incidents. And I believe that it would be appropriate to, when we're talking about the credibility of the defendant, to allowing in 3 of those.
I looked at the date ranges and I looked at the actual counts, and some of the counts, obviously the laws are titled differently in Idaho, but there's a couple of counts that specifically have what I would call dishonesty built into the name of the conviction, the first-degree murder and grand theft by deception. Those are counts 1 and 3 specifically. And again, these only become relevant if the defendant chooses to testify. I did read the defendant's response asking that all of them be precluded. Let me hear from the defendant.
One second, Your Honor. Your Honor, I haven't had a time to, I wasn't planning on talking about the 609 today, so I'll just refer to my reply.
Well, we can table it till later in the trial because, again, it doesn't become relevant unless you choose to testify, but you know my inclination and what the state's argument is.
Okay.
This morning I handed each side proposed preliminary instructions. We don't need to discuss those now, but depending on tomorrow how far we get in the jury selection process, maybe you can be prepared to tell me if you object to any or if there are additions or corrections that need to be made. All right, I think that's going to be it for today, but let me check with the state. Is there anything else we need to address today?
I think just for the record, Your Honor, in terms of allowing in witnesses, the gallery, I think that you had indicated you would reserve 1 row for the next of kin.
Yeah, let's discuss that. We're going to put up signage after we complete jury selection. So the first row on both sides behind defense counsel and behind the state will be reserved for immediate family members, next of kin, those sorts of people, relatives. The very last row on both sides will be reserved for media. And then the middle rows in between those two will be kind of a first come, first serve general public viewing area.